Lillian Daltrey with Representative Chris Humphrey, Sophia Garza, Representative Howard, Ava Geisler with Representative Faircloth, Sidney Hayes with Representative Howard, and Owen Schnurr with Representative Celeste Cairns. Thank you all for being with us today. Members, we're going to begin with House Bill 132, Representative Crutchfield. The gentleman is recognized to come to the podium and speak to House Bill 132.
Thank you, Mr. Chair. House Bill 132 requires government agencies that issue permits to mail those permits to the recipients are issued. They have the option of picking them up. A lot of smaller towns around the state require you to come pick them up, so there's a lot of windshield time to go pick up permits that they could mail to you. This bill would just in the future require them to mail them to you. And I stand for any questions.
Members, is there discussion or debate on the bill? Hearing none, Representative Kyle Hall moves for a favorable report. All those in favor will say aye. All those opposed, no. Ayes have it. Bill receives a favorable report.
Thank you, Committee.
Thank you, sir. Representative Brody, House Bill 579. There's an amendment from Representative Hardister. Does the gentleman want the chair to go to Representative Hardister for the amendment first?
Yes, sir. Thank you.
Please. Representative Hardister is recognized to send forth an amendment, and which of the gentlemen want to speak to the amendment? Representative Brody, gentleman's recognized.
Thank you. Thank you, Representative Hardister, for doing this. Thank you, committee, Mr. Chairman. The amendment is the amendment is basically the bill. What it does is attempts to straighten out what we call redundant permits in the building industry, and with the help of DEQ, we also set the program to do that, to accomplish that. But one step we have to go next is to ask permission from EPA in order to do it, and that's part of also the bill. So we'll stand for questions.
Members, is there discussion or debate on the amendment? Hearing none, Representative Hardister moves for adoption of the amendment. All those in favor will say aye. All opposed, no. Ayes have it. The amendment's adopted. Is there discussion or debate on the bill? Hearing none, Representative Hardister moves for a favorable report to House Bill 579 as amended, rolled into a new PCS, unfavorable to the original bill. All those in favor will say aye. All opposed, no. Ayes have it. The bill receives a favorable report. Thank you, sir. Representative Johnson, House Bill 197. Gentleman's recognized.
Thank you, Mr. Chairman. This is just an agency bill. We met with stakeholders, got everything straightened out, and will help us get the broadband money out more efficiently.
Representative Hardister.
Motion.
Is there discussion or debate on the bill? Hearing none, Representative Hardister moves for a favorable report. All those in favor will say aye. All those opposed, no. Ayes have it. The bill receives a favorable report. Thank you, sir. Okay, members, the chair is going to go ahead and move to Senate Bill 9, Apex Town Council appointments. There is an amendment from the chair on behalf of Representative Pless. This is Ann Hardister is adding in the matters that the House has already passed as to several western North Carolina counties. And the chair understands Representative Paray is handling the underlying bill. We'll go ahead and take up the amendment. Is there any discussion or debate on the amendment? Seeing none, Representative Kyle Hall moves to adopt the amendment. All those in favor will say aye. All those opposed, no. Ayes have it. The amendment's adopted. Representative Paray, does the lady wish to speak to the bill as amended? Please recognize.
Yes, thank you, Mr. Chair. I've been working on this with Senator Adcock, who's here with us today, and I'll just give you a little bit of a brief on what this bill does. This is a local bill. Part of this is a local bill for the town of Apex that will allow the town council and mayor to appoint the town clerk, the town attorney, and manager, and allow the mayor to vote on matters relating to these three positions. All parties involved are in support of this bill, and the other provisions of this bill with regard to Guilford County and Haywood and Madison counties, I'll defer any questions to Representative Hardister or Representative Less. And I know Senator Adcock is also here in the audience, can speak to the bill as well.
Members, is there any discussion or debate as to this local bill as amended? Representative Quick, gentleman's recognized.
Thank you, Mr. Chair. Only to express some heartburn that Guilford County's issue has been added onto what was a good Apex bill, and I don't understand the connection to that. So I'll be voting against it just because of the Guilford County provision, which I think we've handled at least once or twice before.
Members, is there further discussion or debate on the bill? Hearing none, Representative Hardister moves for a favorable report to Senate Bill 9 as amended, roll into a new PCS unfavorable to the original bill. All those in favor will say aye. All those opposed, no. Ayes have it. Bill receives a favorable report. Members, the chair is going to move now to Senate Bill 91. The chair understands Senator Sawery is going to handle this, and there is an amendment, again, from the chair, and
Move for adoption, Mr. Chairman.
that's what we like to hear. The chair will just briefly explain one section in this bill that was mistakenly left in the PCS, and this is removing that, dealing with continuances. Is there any discussion or debate on the amendment? Hearing none, Representative Torbett moves for adoption of the amendment. All those in favor will say aye. All those opposed, no. Ayes have it. The amendment's adopted. Senator Sawery, gentleman's recognized. Speak to the bill as amended.
Thank you, Mr. Chair. This is a bill that was originally brought forward by the North Carolina Bar Association to amend Rule 4 on acceptance service. A PCS has been brought forward to amend Chapter 20 by adding provisions with regard to street racing and street takeovers. I appreciate your support.
Members, is there discussion or debate on the bill? Seeing none, Representative Hardister moves for a favorable report to Senate Bill 91 as amended, rolled into a new PCS, unfavorable to the original bill. All those in favor will say aye. All those opposed, no. Ayes have it. The bill receives a favorable report. Thank you, sir. Members, the chair is going to displace Senate Bill 546 from today's calendar. The chair anticipates adding that back on next time this committee meets. Members, we'll move now to Senate Bill 615, Senator Galey, adoption, conflict, etc. Ladies recognized.
Thank you, Mr. Chairman. Part 1 of this bill would allow a child as an adult to be adopted by a former step-parent. Part 2 would provide for redaction of information from an adoption home study. Part 3 would expand acknowledgement options for agency relinquishments for adoption. Those first 3 parts were all proposed by the North Carolina Bar Association and have been thoroughly vetted through the Bar Association process. Part 4 would address conflicts of interest in juvenile matters and provide an avenue for people undergoing adjudication to get the venue changed. And then Part 5 relates to the guardian ad litem appointment process for unemancipated minors, and I know of no opposition to these provisions.
Members, is there any discussion or debate on Senate Bill 615? Representative John, gentleman's recognized.
I have a question to the bill sponsor.
Gentleman's recognized.
Senators, I understand the conflict of interest provision. It does not, it says a judge can enter a ruling on a conflict of interest without there being any underlying lawsuit filed. Do I have that about right?
Yes, sir. On page 3, line 37, it starts the provision or the part, if there is no petition that has alleged abuse, neglect, or dependency has been filed, there is a process by which a person who is concerned about a potential conflict of interest with the Department of Social Services staff can ask a judge who regularly hears juvenile matters to rule on whether or not a venue change would be appropriate.
Follow up, Mr. Chair.
Gentleman's recognized.
Thank you. Senator, I spent some time as a judge, and I don't recall ever having the occasion to stick my nose into a matter where there was not an underlying court case, which gave me jurisdiction to be involved. I don't understand the change, quite frankly.
Lady has the floor.
Thank you, sir. I think that this statute does give that jurisdiction that the representative would be seeking. That's the purpose of it, is to kind of grant jurisdiction in that case where the petition hasn't been filed yet. The conflict of interest arises when reported abuse, neglect, or dependency involves, for example, an employee of a child welfare division of the county DSS, a relative of an employee of the child welfare division of the county DSS, a foster parent supervised by the county DSS, and so forth. There's a list of 10 items where there might be a conflict of interest. And if a person is involved in that, you can imagine that if there's an allegation that the employee of the child welfare division of the county DSS, if they're actually being investigated for abuse and neglect of their own child or a child in their realm of control, then it would definitely be prudent to have that change of venue. So this gives a process by which somebody who has that concern can petition the court. One would think that the county DSS would do that on their own and wouldn't have to go to court, but apparently that is not always the case.
Well, I thank you for your explanation. I'm not sure I'm convinced, but I appreciate your response.
Thank you, sir.
Members, is there further discussion or debate? Representative Cunningham, ladies recognized.
Thank you, Mr. Chair. I'm looking at the Administrative Office of Courts where it sets the item and it requires the form to be available on the AOC's website. But it goes on to say that each county and the County Department of Social Services to provide the form when requested. Also requires the AOC to develop a procedure for maintaining the confidentiality of the petition. Now, we've ran into issues with DSS counties using different forms for different things. Is this going to be consistent throughout, uniform, everybody required to use the same form?
Lady has the floor.
Thank you, Chairman. Ma'am, I believe that's in the existing law. That's the way, the section 4.3 that I think you're referencing is the way that things are now. So that's not a change. And I assume that it would work the same way it has been working.
Follow up, Mr. Chair.
Ladies recognized.
Thank you. I was looking at it, it said if requested. So if it's requested, that would be only if you ask for. So I was concerned. We've had that issue throughout the state with different departments using different forms to carry out statute, and we need that consistency.
Ladies has the floor if she wishes, but don't have to. Okay. Members, is there further discussion or debate? Do the bill. Hearing none. Representative Hardister. For a motion. See none. Representative Hardister moves for a favorable report to Senate Bill 615. All those in favor will say aye. All those opposed, no. Ayes have it. Bill receives a favorable report. Thank you, Senator Gaylor.
Thank you, Chairman.
Senator Gaylor, if you'll hang out with us, I think we'll go ahead and knock out your other matter if you would like to while you're up there. Members, we're going to move now to Senate Bill 49. Senator Gailey, the lady is recognized to speak to the bill.
Thank you, Mr. Chairman. Senate Bill 49 is captioned the Parents' Bill of Rights. And the objective of this bill is to delineate what the rights of parents in North Carolina are relative to their children, especially considering medical care and the public school system, to help parents to be aware of what their rights are, and also to require local educational units to put in place policies and procedures that give effect to those rights, that notify the parents of what their rights are, and then have procedures whereby there's actual exercise of those rights. So I'm happy to answer questions about particular sections of the bill. It's rather lengthy. If the chair wishes for me to go through the bill and explain it further, I'm happy to do that. I'm here to do what y'all want me to do.
Members, is there discussion or debate on the bill? Representative Dahl, the lady is recognized.
So, last week, we voted to take away some parents' rights, and now we're giving them back. So I need to understand what the purpose of this bill is, because most of these, when I read them, I know my mother was able to access all of this information. I mean, we didn't have, some of these things we didn't have in school. So I'm really concerned and just don't understand why we need this. Because what it seems to do is it seems to largely direct towards children's sexuality and or teaching about two moms, two dads, and that kind of thing. And there's some other stuff in here, but I'm wondering, number one, why that's included and why that, I mean, from all the teachers I talk to, somebody says, oh, I have two moms. Okay, great. And now the color, what color are we looking at? I mean, it's not some huge deal and there's no indoctrination. So I'm confused as to why we need all of this.
Right, so there's a lot to unpack in that question. I thank you for the question. So the question of where this come from and why do we need a delineation of the parents' rights, first, especially vis-a-vis the school system or the medical community. I think that when folks were shut up for a very long time, in Alamance County, we were one of the last school systems to go back to in-person learning. When children were at home with their parents, supervising them and their education, the parents came up with a lot of concerns and questions about the curriculum that they saw, about things that their children were learning. And then when parents approach the teacher or approach the principal, they get the stiff arm. They get the, no return phone call, no return email, a lack of response. Unfortunately, it's pretty common. And I had that experience as a parent where I did not get a timely response when I had questions about my child's education. So I think that's really where the genesis of this bill comes from, is parents having concerns, questions about their children's education and feeling that the public school system is not responsive to what they're asking. So as far as other things, so there are some things in here that are new. It's not a regurgitation of laws that can be found in other places. For example, FERPA, the Federal Records Law, that is in here. But then there are other things that are new, like page 2, line 32 through 35, that a parent would be promptly notified if an employee of the state suspects that a criminal offense has been committed against his or her child. That's new. The main thing that's new in here is the communication of information from the public school unit to the parent. So there's a requirement that they furnish information at the beginning of the school year. How do you get in touch with the school? How do you get answers to questions? And when somebody has a concern, how is that going to get resolved in a timely way? So that's very important. I'm flipping through to the parts that I think you're more concerned about. I think the parts that you were alluding to, page 8, lines 18 through 14, age-appropriate instruction for grades kindergarten through 4th grade, and the previous page, page 7, that the governing body of the public school unit shall adopt procedures to notify a parent of prior to any changes in the name or pronoun used for a student in school records or by school personnel. I would direct your attention that of this lengthy bill, those are less than 15 lines, maybe less than 10 lines of the whole bill. So the thrust of the bill the direction of the bill is not those things, but those things are included in the bill. And if you want me to talk about those particular things, I'm happy to do that.
Representative Dahl.
So, yeah, I mean, what I'm concerned about is I'm concerned about children and abuse, not necessarily from the school system, but from parents who don't agree with whatever they've discussed. They disclose it to a teacher. That teacher is then forced to tell the parents. There are a lot of ramifications in there. And so I'm really concerned about that. I'm concerned because we still have therapies that are harmful to children that are still done due to the fact that the parents don't agree. I'm not saying that we need to run around. I don't want you to think I'm being flippant. I am truly worried that these 2 paragraphs could be detrimental to education as we know it, because we're pitting the teachers against the students, and the teacher's responsibility is to teach the students. And the parent's responsibility is to teach their child whatever values they want to have at home. So I'm wondering, can we just take those 2 paragraphs out and let the bill stand after that?
So Representative Dahl, I appreciate your concerns, and I appreciate the heart from which they arise, and I know that they are sincere and that you're concerned about the welfare of children, as we all are. If there is abuse, if there is present abuse, then we know that the public school employees have a duty to report that to the Department of Social Services. Otherwise, when you withhold information from parents that is vital to their understanding about their child's mental health and their well-being, then they are being adjudicated essentially of potentially abusing them without having a hearing. In the United States, when we take away a person's property, when we take away their liberty, when we take away their rights, there is a legal process that's always followed where, you know, if you want to search somebody's house, you have to have probable cause. If you want to stop and frisk somebody, you have to have a reasonable suspicion that criminal activity is afoot. If you want to take away somebody's property, you know, in a civil matter, somebody has to file a lawsuit, and there's rules of evidence that go through. You know, what I would say that people are proposing is that parents lose the right to essential information about their child's mental health on a mere suspicion of that the parent might or might not do something. And that's not fair to them. That's depriving of them of their right to parent their own child, whether biological or foster or adopted or whatever, their own child. They're being deprived of their right to direct their care, their education, their upbringing, their mental health, their well-being. And it's just on the suspicion of a school employee who is not trained, they're not counselors, they don't know. They're going off of what this vulnerable, insecure child is saying. And maybe there's things going on in the household that the school employee is not aware of. Maybe somebody's died, maybe somebody's getting a divorce, maybe they're facing homelessness or financial insecurity. There can be all kinds of reasons that this child is struggling and suffering. And talking to the parents about those things is essential in communicating or in addressing that child's mental health problems. Also, I understand that there are some, I know, I've read in the newspaper that there are public schools across the country who have adopted policies that we will not tell the parents if the child wants to change their pronouns. I am told that that has also happened in public school units in North Carolina. However, there is no policy against calling the parent if the child's pregnant. There is no policy against calling the parents if the child's doing drugs. There is no policy against calling the parents if the child is acting out in violent ways toward other children. Of all the problems that a child can have, this is the only area that people are pushing to keep the information from the parents. And I think that that is questionable, to say the very least. Why? If you have a child who is suicidal, if you have a child who has mental health problems, the first person that should be called and brought into the conversation is the parents. So, that's my response to that.
Representative Torbett.
Thank you, Senator, for bringing this forward. Would you not, I guess, categorize this as a reaffirmation of the relationship of a parent and a child, as opposed to what some would think it should be between an educational system and a child? And we're putting weight where the weight belongs, is that, like I say, reaffirming the laws, the legal laws of the rights of the parent in relation to their minor children. Isn't that pretty much surmise what we're doing here?
Thank you, Representative Torbett. Yes, I would agree with that. I would say, parents have the duty, they have the responsibility to care for their children. If Representative Dahl has a child, it's not my obligation or duty to help take care of her child. That's her responsibility. If I have one, it's not hers to take care of mine. So we have that responsibility, and the state should respect that and support that in families and not seek to undermine it or undercut it through the action of state employees operating through the public school system.
Representative Clemens.
Thank you, and thank you, Senator Galey. I am a parent to 3 public school children, and I just today was talking to one of their school principals, so I know the importance of parents being involved as advocates for their children, and I respect that you do too and are trying to help parents. My concern is actually comes from after more than a decade serving really high-need school populations and children, many of whom were in really risky situations with their own families or foster care situations. And in particular, on page 7 of the bill, lines 31, it says, in accordance with the right of parents provided in Chapter 114A of the General Statutes, the procedure shall include a requirement that school personnel do one or both of the following. 1, encourage a child to discuss issues related to the child's well-being with his or her parent. And 2, facilitate discussion of the issue with the child's parents. So certainly for many of our children, and probably even most of our children in public schools, discussing issues with their families is what we would want to happen, because we hope, and many of them are in supportive, loving situations with their families. As you referenced, there's a requirement when there is abuse that school personnel report the abuse. What I am worried about is the gray area between those two dynamics. There are many children for whom school personnel are the safest, emotionally, mentally, and physically safe adults that they are with on a daily basis. I have spent my career before coming to the legislature with those children in schools where that was a large percentage. Many of those children, would it technically be defined as abuse to report? Maybe not. Are they still in situations where their mental well-being or their concern that they're worried about is directly related to the adults that they live with, and that being forced to communicate that would lead to more harm for children? Yes. And that gray area is why I'm concerned about this and concerned about the impact, particularly on our school personnel who serve our most vulnerable children. Thank you.
Representative Cunningham.
Thank you, Mr. Chair. I'm going to do a scenario, and it's pertaining to Representative Clemens' statements on the gray area. If a child comes in, the nurse, the staff reports to the Department of Health and Human Services or the DSS, whoever they have to report to, that sexual abuse is taking place inside of the family unit. How are you going to cover that gray area? And number one, most adolescents, most teenagers, they're going to do peer talk. They're going to talk to who they're comfortable with first before they even go to an adult. And then maybe they go to mental health if it's available in the school. That gray area gives that parent, if that child leaves school, if DSS doesn't immediately step into there, the possibility is that child returning back home to that same abusive situation and possibly dying. That's the gray area, and that's a huge gray area for me.
Members, the chair has a number of members of the public who have signed up to speak. Are there any other members seeking to debate before the chair goes to public comment? Representative Torbett, the gentleman
Thank you.
recognized.
I'd also like to bring the members' concern. There are other issues that we are addressing through laws that actually apply to some of the questions that we have. One we just passed recently, which is like a threat assessment that could help determine if a child is having that kind of stress or where they might want to cause harm to themselves or others. So some of these concerns most definitely are valid concerns, but they are being addressed through other legislation that we're running as well.
Members, if no other members seek recognition before the chair goes to public comment, the chair will go ahead and move to public comment. As always in the Rules Committee, we will allow up to 1 minute of discussion. And the chair will begin with, it looks like Cameron Pruitt. Pruitt maybe. Chair apologizes if that's incorrect. To ask this individual to please come to the microphone and identify yourself, and if you're here on behalf of somebody, who you're on behalf of, and speak to the bill for up to 1 minute.
Thank you, Mr. Chair. My name is Cameron Pruitt, and I promise my teachers taught me good handwriting in school. I just forgot. But I'm from Charlotte, North Carolina, and I just want to say that not only is this bill silent on students' rights, it undoes decades of anti-bullying work, such as was done by the late Janice Covington. It makes our state less attractive for families with LGBTQ kids, and it will cause harm by treating people differently solely on the basis of their gender identity and sexual orientation. I benefited from a compassionate teacher, Ms. Terry, when I was being bullied as a young kid. And the actions in this bill will have a chilling effect on those teachers, where kids may not be able to benefit like I did. Finally, if this bill and these rights are so important, why the carve-outs? Why do charter schools and private school kids not get the same rights? Why are their parents being denied rights? It's because, like so many actions this session, this is an attack on our public schools and an attack on the LGBTQ community. If parents should have rights, they should have rights in every taxpayer-funded school, vouchers and charters included. It is an attack, and you've overplayed your hand by making sure that you continue to attack LGBTQ kids. Stop the slate of hate.
Robbie Kern.
Good afternoon. My name is Rebby Kern. My pronouns are they, them, and theirs, and I'm the Director of Education Policy at Equality North Carolina. I'm based in Charlotte. One thing that my educators did really well was allowing me to use all of the 6 names that I went through in high school until I was able to land on Rebby. Even though my parents called me a nickname that I didn't quite love, having my name honored and reflected in school was so important. Even though they weren't able to see the deep abuse that I was going through in school, and I think that's important to name here. But what's also happening to our students right now is even in the discussion of these bills and the mere possibility that they could pass, young people are already reporting that their mental health is dropping, and they're having increased senses of anxiety and depression just with the discussion of this bill. This bill would unfortunately widen exclusions for young people who are already facing bullying, bias-based remarks in school, and I would encourage you to spend your time tightening up ways for educators to better respond to these remarks that are already happening, to further ensure our students are protected from this harm on all aspects, from peers, from educators, and school staff. Thank you.
Ellie Isley.
My name is Ellie Isley, and I'm a trans woman. These laws are aimed at my community. All of them, not just this one. The ones that y'all have passed the other day, where you say that parents don't have a right to the health care of their children. And then you try and do this and say that they had the rights to discriminate and abuse their children. I was lucky in high school. I had a teacher who cared for me. My parents did not know that I am trans until now. They found out through the news because I was never going to tell them because of their views. This probably would have killed me in high school if this law was there and I had no other option. I don't want that for children. It's not okay. And y'all should vote against this.
Jose Velasquez.
Good afternoon. My name is Jose Velasquez. I'm originally from Goldsboro, North Carolina, and I'm now studying economics at Tufts University. So I'm the eldest of 3 siblings, ages 6, 11, and 19, all of which live in Goldsboro, North Carolina. I love my siblings, and if you guys know anything about being the oldest, it's your responsibility to protect, care, and guide them. My siblings are fully aware of my sexual orientation, but that does not matter. It transcends my our label that I have for myself. This morning we're talking about SB 49 and the effects it'll have, and I'm just confused about why it's necessary. During my education, I attended 3 underfunded Title I schools in Dudley, North Carolina. As a child, my concerns weren't really if my teachers were going to talk about sexual orientation or gender identity. My concerns were if my classmates and I were eating enough at home. My concerns were if I was even going to have a teacher for that academic year. So there's bigger things going on right now, and this really isn't a topic that it's important to talk about, but is it worth time? All right. Thanks, guys.
Javier Adams. Again, Chair apologizes. I'm sorry, Xavier Adams. Chair apologizes. Gentleman's recognized.
Thank you, Mr. Chairman. I'm Xavier Adams, and I am the NCAT 2022 Prudential North Carolina Beginning Teacher of the Year. Like many of you, I grew up in the church. My dad is a pastor, and I have 2 degrees in religious studies. It was in the church where I learned to love people as Christ did. It was based on this teaching that I decided to become a public school teacher. As a Christian and teacher, my responsibility is to serve, care for, and work alongside my students to create a better and more accepting world. As politicians, you each share this responsibility with me, regardless of your religious and political party affiliation. If Senate Bill 49 is passed, we will continue to create a society that has lost sight of what matters most in public education, putting students first. Therefore, please vote no on Senate Bill 49 because it does not center the most vulnerable students in our society, being queer students. Thank you.
Hannah Wilson.
Good afternoon, members of the House Rules Committee. I am Hannah Wilson, and I am a first-year teacher in Durham Public Schools at the Durham School of Technology. Senate Bill 49 in its current form has the possibility to enact change that is in direct opposition to the intended goals of this legislation. North Carolina educators, students, legislators, parents, and community members are seeking to create a safe, equitable, and exceptional learning experience for all students. All effective educators know that a school is only as strong as its connection to the community it serves. However, schools for many are a safe space for LGBTQ+ students to explore their identities and be their authentic self when they don't have a safe community outside of the school space. The extremely upsetting reality for 1 in 3 students who identify as being queer, including myself at one point, is that they are not in homes that affirm their identity. Although there are provided exceptions to reporting pronouns and names to parents, the reality is that we cannot understand or guess what will happen when a student goes home. Thank you.
Renee Seckel.
My name is Renee Seckel, and I want to tell you that SB 49 only works for bad parents. And I tell you that because I had bad parents. The cardinal sin in my family was to tell that my mother's nickname for me was Devil's Spawn. That when she got mad, she'd take me by the hair and she'd throw me on the floor and she'd kick any part of my body that she could reach. But that wasn't the worst. I couldn't tell either that when you got my dad really mad and he took his belt off, oh God, you better run. I couldn't tell any of that. I tried once. I did tell a teacher something that was happening. In her well-meaningness, she went and she told my parents, and I have spoken in this body about what happened to me that day. This bill traps children in that gray area where the abuse doesn't rise to the level of removal from the home, but is still terrible and painful and traumatic. And it tells them that they can't tell. There's no parent they can tell, because if they do, either their parents are going to get a call, or the school is going to report to Child Protective Services, and they're going to be responsible for destroying their family, because, yeah, that's something my parents told me too. Please don't do this to us.
Jan Gerard.
Hi, my name's Jan Gerard, and I live in Chatham County. This is, as this previous speaker said, this is a bill that supports poor parenting. I'm fortunate that I have a transgender grandchild, and she's thriving as a 12-year-old because of the acceptance of her family. And she will do fine no matter what all these horrible bills do, because she has the support of her family. I worry about the kids that don't have that support, and they have no one to talk to, no one to go to, except maybe a trusted adult in a school system. And you're saying that they can't talk to that person without them coming to their parents and outing them, basically. So these kids are in danger of self-harm, mutilation, cutting off their breasts, or what have you, and they're going to be traumatized and risk of suicide and self-loathing. Please, the hypocritical 808 that passed yesterday denying parents' rights to affirming gender care, that the hypocrisy is appalling. Thank you.
John Rustin.
Thank you, Mr. Chairman, members of the committee. I'm John Rustin, president of the North Carolina Family Policy Council. For decades, state and federal courts in this General Assembly have recognized that parents have a fundamental right to the care, custody, and control of their children. As Senate Bill 49 clarifies, this fundamental right does not end when a child enters the school building or a healthcare facility. In fact, one of the greatest predictors of child's well-being and success is parental involvement, and Senate Bill 49 seeks to restore transparency and a sense of partnership and cooperation between parents and their child's school and healthcare providers. As for the concerns expressed about the bill outing children to their parents, we have compassion for individuals who are struggling with identity issues and gender dysphoria. However, for a school to willfully withhold this information from parents is a breach of trust and a violation of the parent's right to know, especially when a student has publicly requested to be called by a different name or pronouns by their teachers and fellow students. We urge you to support this legislation. Thank you.
Mary Sumo.
My name is Mary Suma. I'm General Counsel for North Carolina Values Coalition, and I'm happy to support this bill and commend you for bringing it to the committee. In a free society, the family, not the government, is its basic unit. Parents, not educators or doctors, are tasked with the privilege and responsibility to care, educate, and provide for their children. Parental rights are the brick and mortar of the wall protecting the family from government intrusion, and since 1923, in the case of Myers versus Nebraska, the court has recognized parents' rights as fundamental. Parents are tired of public schools and healthcare professionals counteracting these values, hiding critical information, encouraging children to adopt identities and lifestyles that are harmful, using obscene books and materials in the classroom, teaching LGBT ideologies, and I could go on and on. The Parents' Bill of Rights is a good step in addressing some of these problems. It will require that parents are informed of their legal rights. And that's it. Thank you very much.
Kyle Warren Love.
My name is Kyle Warren Love. I am here to speak against Senate Bill 49.
I am a resident of Prospect Hill in Caswell County. I grew up there and I am proud to call it my home today. Growing up in a rural area meant there was only one middle school and one high school in the entire county for me to go to school. Schools should be a place where children can learn to live and succeed in this world. The reality is, this is a world where LGBTQ people exist. I trust parents to raise their kids to be able to respond to those lived experiences in a loving and caring way, even if some people don't agree. That has been my experience living in Caswell. Growing up around and learning from people who have different lived experiences. Learning how to give respect, show love, and figure out how to work together as a community to help children learn, grow, and enjoy being a child. You were elected to represent the will of the people in North Carolina. Voting for this bill wastes our taxpayer money through court costs, money that could go towards the things that parents truly need. Buses that show up reliably, appropriate class sizes. Thank you.
Jeff Anderson.
My name is Jeff Anderson, and I am a resident of Clayton, North Carolina. I'm here to speak against State Bill 49 or Senate Bill 49. I am a parent of 2 children, one who does identify as part of the LGBTQ plus community. Currently, the school is able to weigh the needs of her and her classmates on a case-by-case basis. They can do the right thing. If a student is in danger from their parents, the school can direct resources appropriately. What I'm also concerned about is the students who have abusive parents. Those abusive parents are now getting fed information by the school that can cause direct harm for the children involved. Not everyone has good parents, and this is going to hurt a lot of people. Thank you.
Jason Pickler.
Mr. Chair, I'm here to speak on a different matter, SB 452. Should I wait until that matter is addressed, or should I proceed?
Yeah, Chair apologizes. Okay. Yeah, you can have a seat in the front row right there, as a matter of fact. Senate Bill 49 speakers. The last one is Margot F.
Hello, my name is Dr. Margot Falk. I am a family physician in Caswell County, and I am here today on behalf of my patients to ask you not to pass this bill. I believe it will be incredibly damaging to the mental health of our youth and will create a physical safety threat. Just this past week, I had a 14-year-old girl sitting across from me in my office in tears. She had just attempted to commit suicide the week prior, in large part due to no longer being able to see a future for herself in rural Caswell County. I know many youth who are in these sort of situations, and for some of them, their teachers are the only place they feel able to turn to find a safe lifeline. This bill will rip away that lifeline and will result in higher rates of suicide among our youth. I know that you share the same vision that I do of communities where families are kept together, where youth are safe and supported and able to stay in their rural communities and flourish as themselves and their families. This bill will work directly against that. Thank you.
Members, that's the end of public comment for Senate Bill 49. Is there any other discussion or debate from the committee on Senate Bill 49? Seeing none, Representative Torbett moves for a favorable report. All those in favor will say aye. Aye. All those opposed, no. Ayes have it. The bill receives a favorable report. Members, we're going to move now to Senate Bill 452, NC Department of Insurance Omnibus. There is a PCS, and Representative Hastings moves that the PCS be before the committee without objection. The PCS will be before the committee.
Let me do it.
And Chair understands Representative Stevens is handling this amendment. I'm sorry, the PCS itself. Members, Chair is going to go ahead and allow Representative Stevens to speak to the PCS. There are a couple of amendments we'll get to whenever the lady's ready. Ladies recognized.
Thank you, Mr. Chair, members of the committee. A lot of this is clarifying changes and started as an agency bill, so I will skip over a lot of things and see which ones that you may have more of a question about. We'll start with Part 7, increase minimum liability limits for insurance required through the state. And we had already passed this bill to the Senate. They hadn't taken it up, so we stuck it back in here to send back to them. Section Part 13 clarifies a timeline that when there's a personal injury case and you've subpoenaed the medical records, they must be produced within 120 days in order to protect their medical lien. Part 14 is the standardization of evidence to prove a debt starting at the point of charge-off. Before a debt is charged off, the original debtor must account for every cost, fee, late fee, interest, penalty. But when it's charged off, there becomes a set amount, and the collection agency under this would start from that point, keeping up with cost and expenses. Part 15 increases small employer access from it would lower the maximum number of employees who may purchase stop-loss insurance from 20 to 5 so that more small businesses can get into that catastrophic loss and self-insurance. Part 17 raises the beach plan policy limits, and then we have an effective date. Be happy to stand for questions.
Members, the Chair is going to go ahead and go to the amendments. The Chair has an amendment, ACL 28 version 2, and this amendment just ensures that the bill complies with the federal HIPAA law. Is there any discussion or debate on this bill? This amendment, rather. Seeing none, Representative Torbett moves for adoption of the amendment. All those in favor will say aye. All those opposed, no. Ayes have it. The amendment's adopted. We'll now move to Representative John's amendment. The gentleman is recognized to send forth Amendment ACL 26 version 2, and the gentleman is recognized to speak to the amendment.
Thank you, Mr. Chairman. Members, this amendment deals with the provisions in pages 24 and 25 of the bill. On page 25, Section 4C recites the current law, which is being deleted, and on page 24, and at lines 34 through 41, is the proposed law, which is set out there. My amendment would delete the proposed law and reinstate the current law, which simply recites, in my view, a common sense list of information that courts require to enter judgments in these issues of debt collection actions. I could remember way back when I was a judge, we didn't have the law now found on page 25, and these matters were difficult to do because folks coming into court typically did not have the information required. We've had this law since, I believe, 2009, which sets out clearly and fully the common sense requirements and the information needed for the court to enter a judgment. I don't believe I understand, quite frankly, the reason why that should be changed, and my amendment therefore strikes the provision for changing that law and keeping the current law. I'll be happy to answer any questions if there are any.
Representative Stevens, the lady is recognized to speak to the amendment.
Thank you, Mr. Chair. This is not my dog. I'm just walking it, so I don't have a problem with the amendment.
Members, is there any other discussion or debate as to the amendment? Seeing none, Representative John moves for adoption of the amendment. All those in favor will say aye.
Aye.
All those opposed, no. Ayes have it. The amendment is adopted. Members, is there any discussion or debate on the PCS as amended? Hearing none, Representative Stevens moves for a favorable report to the PCS for Senate Bill 452 as amended, rolled into a new PCS unfavorable to the original bill. All those in favor will say aye. All those opposed, no. The ayes have it. The bill receives a favorable report.
Mr. Chair.
Representative Stevens, ladies recognize.
You had one person that wanted to speak. I don't know what they wanted to, I mean, they wanted to speak on 452, but we sort of skipped them.
And again, Chair apologizes. A lot of quick moving things today. I believe the gentleman may have been speaking in favor of that amendment that just passed. Well, just let a good thing be a good thing then. You're free to go. All right. All right, members, there being no further business before the committee, committee is now adjourned.